And we are back, picking up in chapter 6, page 141. On July 29th, a hearing was held at the magistrate. Hold on one second. At the magistrate of Norman Black U.S. District Court in Houston. The courtroom was completely filled with spectators, and although the news media had been contacted and no representatives of the press were there, there's a new media blackout on this matter here in Houston. Brief oral arguments were presented. The U.S. Attorney explained that I was not the proper person to bring the suit because although the free exercise of my constitutional rights was threatened by the concentration camp program, as alleged, it did not constitute my injury. The magistrate was impressed with the information I had thus far collected and stated that he would bring it to the attention of the federal judge. The U.S. Attorney tried to have my investigation of the case halted, but the magistrate would not go along with that far with a prearranged decision. As an additional indication of what I was up against, the original hearing was scheduled for 10:30 in the morning. However, the U.S. Attorney secretly had the time changed to 2:30 in the afternoon. The magistrate gave the U.S. Attorney permission to file for a motion to dismiss because he felt that the concentration camp program to be used for persons who exercise their freedom of speech did not present any injury. Now, on July the 23rd, I had placed in the Houston Post and in the Houston Chronicle newspapers the following advertisement in the legal section: solicitation for witnesses in civil action 78 H.667, Federal District Court of Houston, People X Rel, William Pass versus Gerald Ford et al. The action titled Complaint Against the Concentration Camp Program of the Department of Defense. Attention, if you have participated in Operation Garden Plot, Operation Cable Splicer, the 300th Military Police Prisoner of War Command, or the Army Reserve Civil Affairs Group, you may be involved in a program that needs to be disclosed for this suit. To give your testimony, call or write, and here I place my name, address, and telephone number. As I previously mentioned, there is a news media blackout on the story here in Houston. Both newspapers refused to carry the ad. First, at the Houston Post, I had to threaten them with the lawsuit to carry out the ad, even though I was paying for it. And then at the Houston Chronicle, I had to meet with the president and various vice presidents because a refusal from the paper had come up from their own lawyers. Both newspapers finally carried it, but only after 2 days of complaining. The initial response of both papers was, "We don't carry stories like that, and don't you think that the people planning the concentration camps have our best interests in mind? As you will hear for yourselves, the policies definitely do not reflect our best interests." The next event that occurred was that the U.S. Attorney filed a statement of authority showing the reasons that he could find why I should not be allowed to take the depositions to get more information from the person who was writing the concentration camp guard training program. However, his brief was completely filled with misquotes of the law from many cases. He would mention the case and then invent whatever the case should say. In my brief to the court, at this point, I notified the judge of the violation of the law requiring honesty in such matters, but the notification was ignored by the judge, who apparently sanctioned this most dishonest of acts commonly known as quoting out of context. The Geneva Convention. My brief was filed in August 31st. Formal arguments were set. The new courtroom of the magistrate was almost filled again. However, no one from the news media showed up for this hearing either. The few who were contacted had been told not to go. They would lose their jobs. At the hearing, I introduced evidence that heretofore had never been introduced in any court of law in the United States. The U.S. attorney had denied you will remember everything in my suit without so much as even a tiny investigation. So I introduced into evidence the following letter from the Department of the Army, Office of the Deputy Chief of Staff of Personnel, signed by 1B Sergeant Colonel G.S., Acting Director of Human Resources Development. The letter states, on behalf of President Ford, I am replying to your letter 27th May 1976 regarding a new article in the Dallas Morning News. As much as he would like to, the President cannot reply personally to every communication he receives. Therefore, he has asked the departments and agencies of the federal government, in those instances where they have special knowledge or special authority, underload. For this reason, your communication was forwarded to officials of the Department of Defense. Within the Department of Defense, the Army is responsible for custody and treatment of enemy prisoners of war and civilian internees as defined under terms of the Geneva Convention of 1949. Therefore, the Army is prepared to detain prisoners of war and detainees as defined in Article 4 of the 1949 Geneva Convention relative to the treatment of prisoners of war and protection of civilian persons. It is U.S. policy that its armed forces adhere to the provisions of international law to set the example for other countries of the world to follow in respecting the rights and dignity of those who become victims of international conflict. It should be noted that the Army program is designed for implementation during conditions of war between the U.S. and one or more foreign countries. The Army had no plans, nor does it maintain detention camps to imprison American citizens during domestic crisis. The problem with this letter is that it's not true, and that's why I'm going to discuss it at this point. First of all, in verifying the authenticity of the claims in the letter, I checked the Geneva text. There is no article in the Geneva Convention entitled as the letter states. Therefore, there is, however, on each one of the classifications, protection of war victims, civilian persons, and a separate article on prisoners of war. That was the first discrepancy. Then I turned to Article 4 of the Geneva Convention. The article did not set up any requirements or authorizations for military units of any type and does not even suggest it, hence the second discrepancy. The next problem with the letter from President Ford's representative is that it states that the prisoner of war guard program is set up for the implementation for conditions of war between the U.S. and one or more foreign countries. However, Article 3 of the Geneva Convention reads that the treaty applies to, and I am quoting, in case of an armed conflict not of international character occurring within the territory of one of the high contracting parties. Obviously, an armed conflict occurring within one's own territory did not mean between one or more parties to the treaty, especially if only one is involved. KKKK. Now, the examples of this type of conflict are civil war, armed insurgency, and guerrilla activities. In other words, they're speaking of a domestic conflict. An even more shocking item is found in the last pages of the 1949 Geneva Convention under protection of war victims, civilian persons. You will find the index card, the identification card forms to be used to write in your family, and everything necessary for the administration of a concentration camp is contained in this treaty that the U.S. signed and ratified. Further, if there is a conflict in the U.S. involving only the U.S., This convention or treaty can go into operation, which includes the procedures for setting up the concentration camps. Article of the convention states, and I paraphrase, if you commit an offense that is solely intended to harm the occupying power, not harming the life or limb of members of the occupying power, but merely talking against such a force such as martial law situation, you can be imprisoned, provided that the duration of such imprisonment is proportionate to the offense committed. Well, President Dwight Eisenhower didn't feel that provision was strong enough, so he had the following additions placed in the treaty, which states the U.S. reserves the right to impose the death penalty in accordance with the provisions of Article, I don't know what L stands for, without regard to whether the offenses referred to therein are punishable by death under the law of the occupied territory at the time the occupation begins. So not only can you be imprisoned for having exercised freedom of speech, you can be put to death under the provisions of the Geneva Convention in 1949 for having exercised or attempting to exercise freedom of speech. The next item that I introduced into evidence was a field manual, FM 41-10, Civil Affairs Operation. You will remember at the outset that I mentioned civil affairs groups. Let me quote to you from that manual what one of the functions of the civil affairs activities includes. Item 4, assumption of full or partial executive, legislation, and judicial authority over a country or area. So let's see what a country or area is defined. As in the same manual, it includes small towns and rural areas, municipalities of various population sizes, districts, counties, provinces, or states, regions of national government. Nowhere in the manual does it exclude this program from being put into effect. Right here in the United States, as a matter of fact, in Kearney, New Jersey, the Civil Affairs Group went into that area and practiced taking over that government unit. And yet the Army, in its letter of June 16, states that these programs are not for us. Yet they are practiced here in the United States under conditions that can only occur here at home. The study outline of Field Manual FM 4110 on page J24 under Penal Institutions 1B, you see there is a program on concentration camps and labor camps, number, location, and capacity. It is important to note that a concentration camp and a labor camp are always located near each other for obvious reasons. Again, on page D4 of the same manual, you'll find a sample receipt for seized property, a sample receipt with written English and containing terminology applicable to U.S. territory. On page 8.2 of the same manual, under the heading Tables of Organization and Equipment, we find that there are 3 other organizations that would be working along with the Civil Affairs Operation: the Chemical Service Organization, the Composite Service Organization, and the Psychological Operations Organization, along with various civil affairs organizations. In July of that year, 1976, the following Civil Affairs Group met with the following airborne groups at a staging area in Fort Chaffee, Arkansas. A staging area is where military units meet before they go into action. They met with the 32nd Airborne and part of the 101st Airborne, the 321st Civil Affairs Group of San Antonio, Texas headquarters, the 362nd Civil Affairs Brigade from Dallas, Texas, the 431st Civil Affairs Company from Little Rock, Arkansas, Arkansas headquarters, the 306th Civil Affairs Group, and William Hickling, the 486th Civil Affairs Company from Tulsa, Oklahoma, the 418th Civil Affairs Company from Kansas City, Missouri,